It was a date and a time that was set for a hearing for non-payment of rent. Mr. Dewar, how are we proceeding?
Thank you. I've met with the defendant and we have come to terms on a conditional dismissal proposed for your review. Would you like me to go over those terms on the record?
Yes, please.
Thank you, Your Honor. Rent to retain possession through today's date, through January, excuse me, is $2,450. And court costs are $158.16. Total is $2,598.16. The defendant, under the terms of the conditional dismissal, has agreed to pay $500 on Tuesday, February 6th, $500 on Tuesday, February 13th, and then an additional $400 each Tuesday beginning the following Tuesday, February 20th, 2024, until the balance is paid in full. The defendant also not on the terms of the agreement, but expects to receive a tax return soon and would like to pay the balance off sooner.
Okay.
Thank you. May I approach?
You may.
Thank you.
Okay, Mr. Royal, is what Mr. Dewar stated on the record your complete and accurate understanding as to how you want to proceed?
Yeah.
And you understand that in order to proceed in this manner, there were certain rights that you would need to give up? Question. Do you understand that in order to proceed with the conditional dismissal, you have to give up certain rights?
Okay.
Do you understand that? That was a question. You don't understand
no.
that? Okay. Well, you have the right to be represented by an attorney. We advise you of that right back in December at your first court appearance. Do you recall us playing a video?
Yeah.
Okay.
Yeah.
And that video went over your rights. One of them was your right to be represented by an attorney at a landlord tenant eviction proceeding. You've appeared today without an attorney, correct?
Yeah.
Are you waiving your right to an attorney so that you can move forward with this agreement?
Yes.
Okay, you also have the right to have a trial and you have the right to a jury trial. Did you want to waive your right to a trial in order to move forward with this?
Yes.
Okay, and you don't have any applications pending for rental or housing assistance right now, do you?
Assistant.
Have you applied with any agencies so they can pay your rent?
Yes, I have.
And you have applications pending right now? Or were they denied? They were denied? Okay, so you don't have anything pending. Okay, and so you are agreeing based on this to have the case dismissed today upon the condition that you will pay in full rent to retain $2,450 plus court costs $158.16 for a total amount due $2,598.16, correct?
Yes.
Okay, and that will include your rent due and owing up till today. You understand that?
Yeah.
Okay, and that you are agreeing that you're going to pay $500 no later than the 6th of February, 2024, and then you'll pay $500 on the 13th of February, 2024, and then you will pay $400 each Tuesday beginning February 20th, 2024, until the balance is paid in full. Do you understand that?
Yes.
Okay, lastly, you understand that partial performance will not satisfy this agreement. That means that you need to follow this to the T. You can't deviate from that, okay? You understand that?
Yeah.
Okay, and so I understand that you may be able to pay that sooner depending on your tax return. However, if that doesn't pan out, the tax return doesn't come as quickly as you think it is, or it doesn't come at all, what's going to happen is you're still responsible to make these payments on the dates that you said you're going to make the payment. So you can't make the $500 payment on the 7th and think that this will still stand, because you said you'll make it by the 6th. You understand that? Is that a yes?
Yes.
Okay, do you have any questions?
No, I'm just thinking about it.
No problem. I'm here to answer those questions if you need us to answer anything. That's why I'm asking you, okay?
Yeah.
Okay.
Yeah, I'm fine.
Okay. Lastly, your signature is here. You signed this document?
Yeah.
Okay, you have 3 business days from today. If once you leave here, you realize that you misunderstood the rights that we went over that you waived in order to enter into this agreement, you can return to the court, request to have this set aside. We will set it for a hearing, okay? You want me to repeat that for you?
Yeah, just said it.
So you get 3 business days from today's date, so by Monday. If you, over the weekend, realize, I really didn't understand the rights that the judge went over with me, and I think I want an attorney. You can come back to the court, you'll file a motion at the clerk's office to set aside this agreement here, and then we'll set you for a hearing date, okay?
Okay.
Okay, so you get 3 business days to process whether or not you understood the rights that we talked about, okay? Okay, do you have any questions at this time?
No.
Okay, any additional matters for the record, counsel?
Nothing from plaintiff, Your Honor. Thank you.
Anything else for you, sir?
No.
We'll get you a copy of this and you'll be on your way. Thank you.
Thank you.
Mr. Dua, is that the only one you had?
I have one at 2 o'clock here.
Okay, very good.
I haven't seen here yet. Thank you. Just take.
Counsel, who do you have with you? Who are you ready on?
Okay, Your Honor, we have, Mr. Career is here, as the defendant, we have Woodside Meadows.
Woodside Meadows versus Mr. Greer, is that the one here? Okay. On the record in the matter of the Woodside Meadows Apartments versus Bernard Greer, file number 23-02145. Appearance, counsel.
Good afternoon, Your Honor. Michael Zappin, P68107 on behalf of the plaintiff.
Sir, what is your name?
Bernard Greer, Junior.
Okay, Mr. Greer, today was the date that we reset this matter for a hearing. You filed a counterclaim answer. Let's see. Did you make you didn't make a jury demand, is that correct?
Correct.
Did you receive, the plaintiff's response to your counterclaim?
Yes. Then. So we said
You received a copy of what they filed in response to what you filed? That's
No.
my question. You did not?
no.
You have a copy for him? You didn't receive that?
No, ma'am.
It's the first that you've seen that?
Yes, ma'am.
They filed it with the court back on December 15th. Was a copy served to him?
I think on the back page, our secretary indicates that she did serve a copy.
I received nothing, ma'am.
Okay.
Captain, they wrote back on the last known address to be a first class mail.
Correct. Now I'm assuming you're still residing in the property
Yes, ma'am.
on Woodbridge Drive, correct?
Yes. You're
I'm
right.
not sure why you would not have received it then. You need to get your copy of that because we can't proceed if you haven't received their response.
That's not, ma'am.
Have you all talked today?
Yes.
Briefly.
Okay. Did it come to any resolution?
No, Your Honor.
No, Your Honor.
Okay. When he comes back, I'll get a copy of yours
Thank you.
to give you a copy so that you can review that. And I'm gonna have to set your matter for a new date.
Okay.
Thank you. I'm not sure. I can't even open on this right now.
I have a question.
Yes, sir.
So I subpoenaed them for the move-in checklist, in which I was just told today that because it was under some type of different management or whatever, that wasn't available for them to provide to me.
You
So
subpoenaed who?
the,
You subpoenaed the landlord for
Yes.
what?
the move-in checklist,
Okay, the moving checklist. I'm not following what you subpoenaed them for.
the move-in checklist, okay, when you first move into the apartment, they give you a checklist of anything that's wrong.
Okay,
or
so when you
could
say
be
you
addressed.
subpoenaed them, mean you were requesting that from them?
Yes,
Okay, So, okay, did your client receive that request?
We did receive that request. I did talk to the property manager. She indicated when the property was purchased after they moved in, those records were not forwarded to the new property management, so we don't have a copy of that check-in list.
But I didn't learn that till today.
You didn't learn today that that wasn't available, is that what you're saying?
Correct.
Okay, and did the property owner, the previous property owner, that entity is no longer in existence, is that?
It was purchased. I can have my property manager is leaving today, so I have no property manager after today. But we can try and reach out through whoever they replace them with to see if that
I
company.
think they need to do their due diligence.
Okay.
They're gonna take ownership of property to make sure they get the files.
Okay.
So they can provide them to him. I'm sure they got a copy of people's leases when they took ownership.
We did get the leases, correct.
They should have. If they didn't, they didn't do their due diligence. So I'm gonna require they make some good faith effort to try to get those records. And then you'll get an update as to whether or not that's possible or not, okay? Is that a copy? Yeah, okay. Provide him with this copy, we get a copy there of the counter defendant's
Thank you very much.
response, and then we'll get you a new date.
Thank you, Your Honor.
February 28th at 2. February 28th at 2 p.m., okay?
Understand.
Do you have any questions?
No, Your Honor.
Okay, any additional matters for today, council?
Nothing, Your Honor.
Okay, you're all set for today, sir.
Thank you, Your Honor. Am I waiting for paperwork?
Yeah, just take a seat. I'll give it to you. Gonna wait all the way.
Okay.
Who's the individual identified as Chelsea's iPhone?
Chelsea Brooks.
Okay, your notice was to appear in person.
Oh, I thought it was via Zoom. I'm sorry. I just had to pick my daughter up from school on the other side of town. I literally just got home.
Yeah, the top of the notice says appear in person.
Do you want me to come down
Mr.
there?
Dua, let me see if I can get Mr. Dua to log in and meet with you. If you have to, if you need to move forward with the hearing, you're going to have to appear in person.
Okay.
Did you see Mr.
My
Dua out there?
apologies.
Did you see Mr. Dua out there?
No, I did not.
He might be in another courtroom. Thank you. Have a good one. Sir, what's your name?
John Lemke.
Oh, okay. So on the record in the matter of John Lemke versus Anisha Lewis, file number 23-03458. Okay, ma'am, state your name for the record.
It's Anisha Thomas.
Anisha Thomas, formerly Lewis?
Yes, ma'am.
Okay. And what's your name again, sir?
John Lemke.
Okay, today was the date and the time that was set for the hearing, and this is for a non-payment of rent eviction, correct?
Correct.
Okay, two of you had a discussion about whether or not you can resolve this matter?
Yes,
Okay, how do you want to proceed?
Tanisha and I've come to an agreement that $583.76 for other money due is owed, and I'm okay with setting a date of 2/16/2024 for her to pay it.
Okay, what is it that you're doing? A conditional dismissal?
Yes, we have conditional dismissal set up.
Can you get that?
Thanks.
That's what you want to do, ma'am?
Yes, because I don't over it. It was, some, cherry they took off the porch. So
I'm sorry, it's just what?
it's for, a chair that was on my porch that they have removed off the porch. So it's not rent.
A chair was on the porch? Sir, what does that mean? Was that a citation or something?
Yeah, there was
Okay.
a citation, written. I have a record of it.
I just trying to clarify what she means. I
But it's-
assume she
it's
meant
not-
Yeah.
something was on the porch that wasn't supposed to be there and you got cited. Is that what it is?
Yeah, then it did get, taken care of, so they did us for 565. And so of the 583, most of it, I'm agreeing is not rent. We're calling it other costs because it's related to this trash hauling. I guess if you wanted to look at the
Most of it is not rent? Is some of it rent?
It's $100 for, late fee.
$100 in late fee for rent or other money, I should say. And then the citation was for how much?
Well, it was originally for 565, but Anisha's already paid $100 towards that balance, so I had it at 465. I can show you the breakdown of what I have. It's a lot simpler to look at it in numbers.
It's $465 and then it's $38 and something for, the processor server fee.
It
And
just
$100 for late fee.
depends how you want to look at how it was all applied. I'm agreeable with her or not in disagreement anyway. But there's still-
Process server fees for court filing, is that what you mean?
Yes,
Okay, so that will go under court costs.
I'm sorry.
No. 3826 is for. I see here
I paid that part.
oh, you pay the
Yeah.
112.5 for court costs, correct? Okay, so she owes 3826 for the service. 3826. And then other money due would be the money that you, for the trash hauling, the 465.
Correct.
And then what was the late fee?
Yeah,
See, December
and
late
January,
fee,
2 late fees.
January, okay. I have a total of 60326.
I'm still agreeable to the 583. That's what we agreed on in the hallway and I don't know that,
Okay.
it doesn't need to be more.
Okay, that's accurate. You agree to the 583.76, correct? Okay, and so you understand in order to enter into an agreement whereby the case will be dismissed today upon a payment of 583.76, that you would have to give up certain rights before you could do that. You understand that? One of those rights is your right to be represented by an attorney. You are aware you have the right to be represented by counsel at this proceeding.
Yes, ma'am.
Are you waiving your right to counsel?
Yes, ma'am.
You also have the right to proceed to a trial. You can have a jury trial. Do you want to waive your right to trial?
Yes, ma'am.
Okay. And you don't have any applications pending for assistance to pay any past due rents right now?
No, ma'am.
Okay. Anybody threatening you or promising you to make or waive those rights to make this agreement?
No, ma'am.
You have 3 business days from today's date. If once you leave here, you realize you did misunderstand the rights that you just gave up, you can return to the court, request to have this conditional dismissal set aside. We'll set this for a hearing, okay? And then you would have to advise us as to how it was that you misunderstood your right. So again, you're agreeing to pay the total amount of money due, which include court costs, past due late fees, and the amount for trash hauling, $583.76, and you'll pay that on or before February 16th, 2024, correct?
Yes, ma'am.
Okay, I'll get you a copy of this. Do you have any questions for the court?
No, ma'am.
Any additional matters today? Okay, we'll get you both copies of this.
Thank you.
You're welcome. Oh, you can get this back too.
Yeah.
Hi, let me see. Are they in the courtroom? Okay, on the record, in the matter of Angelique Laurie versus Mindy McDaniels, file number 23-06021, come up to the table. Okay, what's your name, ma'am?
Angelique Lee.
Okay, and what's your name? Okay, today was the date that was set for a hearing for non-payment of rent. And my understanding is that the parties have resolved the matter.
Yes, ma'am.
Okay, so you want to move to have the matter dismissed?
Yes.
Okay, and so I will make sure that the matter is dismissed. Let me see if I can print or dismiss it. Yeah. You have any questions today? You have any questions?
No.
Do you have a seat outside of dismissal and get it to you, okay?
Okay, thank you.
You're welcome. Top of both sides, where it says plaintiff. Right here. Side of that section. Mr. Dewar, you ready?
Yes, sir.
Okay. On the record in the matter of 520 Oakland LLC versus Chelsea Brooks, file number 23-03129 LT, appearance counsel.
Thank you, Your Honor. Sam Dewar here on behalf of the plaintiff.
Okay, and then Chelsea Brooks is present via Zoom without counsel today. Today was the date that was set for a hearing for non-payment of rent. Did you all come to a resolution?
Yes, Your Honor. The defendant and I spoke in a Zoom breakout room, and we have come to terms on a proposed conditional dismissal for your review. May I go over those terms on the record?
Yes, please.
Thank you. Your Honor, Rent to retain possession through the end of February, so February 29th, 2024, is $6,175. Costs are $157.90. That total is $6,332.96. The defendant has agreed on this conditional dismissal to a payment plan of $4,000 by February 15th, 2024, and the balance $2,332.96 by February 29th, 2024. May I approach with that conditional dismissal for your
Yes,
review?
please.
Thank you.
Okay, and Ms. Brooks, is what Mr. Dewar stated on the record accurate as to how you want to proceed?
Yes, Your Honor.
Okay, and so there's certain rights, ma'am, that you need to give up if you want to move forward with a conditional dismissal. Do you understand that?
Yes, ma'am.
Okay, so you have the right to be represented by an attorney at your court proceeding today. Are you appeared without an attorney? Are you waiving your right to counsel?
Yes, ma'am.
Okay, you also have the right to a jury trial. You did not file a jury demand in this, correct?
Correct.
Okay, and are you waiving your right to jury trial and so that you can proceed with a conditional dismissal?
Yes, ma'am.
Anybody threatening you to get you to do that?
No, Your Honor.
Do you have any applications pending right now with any agencies that will pay or help pay your past due rent?
No, Your Honor.
Okay, so you want the case dismissed today upon the condition that you will pay past due rent to retain $6,175 plus court costs, $157.96 for a total of $6,332.96. And that's for rent due through a period of February 29th, 2024. You further agree that you're going to pay $4,000 by the 15th of February 2024, and that you'll pay the balance of $2,332.96 no later than the 29th of February 2024, correct?
Correct.
You understand that partial performance under this agreement will not satisfy. So that means you have to perform fully, as I just stated, according to your agreement. So that means you can't pay $3,999.99 on the 15th and expect this agreement to stand. You have to do exactly what you're supposed to do on the date you're supposed to do it. You understand that?
Yes, Your Honor.
Because if you don't, then Mr. Dewar, on behalf of his client, can file with the court and have a judgment entered immediately against you, and then a writ of eviction could enter against you. You recognize that?
Yes, ma'am.
Okay, lastly, you gave Mr. Dewar permission to sign this conditional dismissal on your behalf.
Yes, Your Honor.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you just gave up, you can return to the court, request to have the conditional dismissal set aside, and we'll set it for a hearing, okay?
Okay.
Do you have any questions for the court?
No, Your Honor.
Counsel, any additional matters?
Nothing for plaintiff, Your Honor. Thank you.
Thank you. Thank you. You're all set for today, Ms. Brooks.
Thank you.
On the record in the matter of Hamilton Road LTD versus Claude Miller, file number 23-01344 LT, counsel appearance.
Good afternoon, Your Honor. Gene Turnwell, on behalf of Hamilton Road Limited, my client is here in the court.
Good afternoon, Your Honor. Darwin Fair on behalf of the defendants, and I understand my clients are present in court today.
Who are you, sir?
Is that Tony Fair, Daryl Davis?
Is that you can have a seat there. Is that your client? No, you have a seat back there. I don't know who your client is, Mr. Fair.
Well, there's a number of them, and I'm not sure exactly which ones showed up, but if they identify themselves, those are the clients and the defendants in this matter.
Okay.
I'm one of them. Daryl Davis.
Daryl Davis is one of your clients?
That's correct, Your Honor.
Okay. Who are your other clients? Mr. Fair.
Yeah, Betty Miller. I understand that she is sick, and maybe there was a representative from her house who's there. If you could ask Daryl who else the defendant is there, because I can't see, Judge.
I'm not going to ask your client who else is here. That's your job. That's why you're supposed to be here in person.
I'm the only one here.
I didn't ask you any questions. I just said I wasn't going to ask you. I don't know how you can represent and talk to your clients. You want me to discuss with your clients who's here? Should I go out in the hallway and check for you?
No, Judge, that's my client who's here. That's
I only have one person in the courtroom that I guess you're representing. I don't see anybody else here.
That's correct, Your Honor.
Okay, first, I think there was a motion that was received while I was away. States here, motion. Defendant's attorney ex parte motion for Zoom hearing.
That's correct, Your Honor.
Okay, so why are you filing a motion for a Zoom hearing?
Well, Your Honor, I am currently in Florida. That is where I spend my winters. And I don't plan to come back until Michigan until the spring. So it would be an undue burden on me and my clients for me to come to Michigan for one hearing and then go back to Florida. And I've been in Florida since last year. And I spend my winters in Florida. This is my 4th winter in Florida. And I have a thriving practice, and it's never been a problem in the past.
It's never been a problem in the past. I'm not following.
That I have to be in court while I'm in Florida.
Well, yeah, I don't know if other courts let you just hold evictions over until you come back to Michigan. I don't know how that's reasonable.
No, Judge, I do it through Zoom, just like during the pandemic. It's just been in my world, it's been a continuation of how it's been during the pandemic.
Okay, well, no, we do hearings in person. It's virtually impossible for me to conduct a meaningful hearing. I mean, you could even tell me if your clients were here today via Zoom. So how are you supposed to supposed to talk to your clients and get questions? And you on the record, they may have something that they want to share with you. They're in the courtroom, you're via Zoom. It prejudices your client if you attempt to run a hearing in that way. We can't even meaningfully exchange exhibits via Zoom. I don't like being talked over when I'm talking either. I don't hold hearings via Zoom. I don't care if you're a snowbird or not. This was set for in-person hearing. It's been set for in-person hearing. And you knew that the entire time. Did you talk to Mr. Turnwell to see if he would stipulate to an adjournment?
No, I did not.
Why wouldn't you do that?
Because every time I talk to Mr. Turnbull, it doesn't end up well.
Is there an objection to an adjournment?
Yes, Your Honor. Today's the day for the trial. We're here. This is for possession only.
Your Honor has already ruled that Hamilton Road is entitled to possession of the premises. This case has been maliciously delayed for approximately 7 or 8 months now by a frivolous appeal, which is now in the Court of Appeals, and possibly may even be dismissed yet today. If not, it soon will be once again. And I have no doubt they'll take it to the Supreme Court. And it's simply for delay. We're asking for possession. The only occupant here is Mr. Davis. He is not a party to the circuit court case or the Court of Appeals case. He has no right to any stay. If he wishes to apply for a stay, it needs to be done in circuit court or the Court of Appeals. There is approximately $4,000 that has been placed into an escrow account. This is an underpayment. The court has ordered $1,600 a month to be paid, and the $1,600 a month has not been paid. We ask that those funds be released to Hamilton Road as well.
Can respond, Mr. Chair.
Well, Your Honor, if I may, I filed a motion for clarification for the status of the case. The last time we were in court was in December the 19th. My understanding as a result of that hearing, that the court was already going to grant possession to the plaintiff. So that's why I asked for this motion of clarification for the status of the case, because my understanding of what happened on the 16th is the court has already made that determination. That's number one. The number two, what I had asked, Judge, is that if the court is going to grant possession to the plaintiff, that's fine. However the court wants to rule. Only thing I ask is that I can get a copy of the order because my client would appeal to the circuit court. In order to appeal to the circuit court, they have to have a copy of the order, and they have to appeal within 10 days. So
I've not made any ruling on possession. We've not had a hearing on that.
Well, I got a signed order saying that occurred on the 19th.
I don't have a clue why you got an order saying that. That's why this is set for hearing today. You should have got a notice of hearing. And the reason why we were having the hearing is for the issue of possession. We never addressed that. The only thing we ever addressed was a stay. And then we addressed escrow and that amount. I never granted possession. I've not even taken any testimony, any argument. None of that's ever happened.
Well, Your Honor, if I may, if you look at my motion for clarification, there should be an exhibit that the court signed on the 19th of December.
You talking about the order for motion for reconsideration?
Right, and then the rest of it indicates that it's going to have possession for the plaintiff. And that's why at that point, we were understanding that you had granted possession for the plaintiff. And only thing that we needed at that point was to appeal to the circuit court. So this hearing, we didn't see a reason for this hearing because we thought the court had already ruled. And
we never actually had a hearing we've not addressed possession. So if the order addressed possession or writ of eviction issue, that's an error because we've not addressed possession. What we addressed thus far, back and forth a lot, was the stay of the eviction proceeding. I said that I was not going to stay the case anymore. And so I said it for a hearing, and you were supposed to get your clients here. That's why today's date is set for two dates.
Yeah, well, and Judge, only thing I can say to this court is that is why I filed my motion for clarification, because after looking at that exhibit, it says.
But you did get notice of a hearing on termination of tenancy for today, correct?
Well, yeah, and that's why I filed my motion for Zoom. But
So you knew that we were coming today to address tenancy?
No, I did not know. I did not know. It says, because I'm looking at
Well,
your
then why
order,
did you
Judge.
file a motion? Then why did you file a hearing to have a motion to have the hearing via Zoom? If it's you knew it was set for a hearing today for termination of tenancy, so you filed a motion last week, the 25th, to have that hearing held via Zoom.
Well, Judge, I also filed a motion for clarification.
That's
And
not set
that's
for
what-
today. I don't see that on my docket.
I said it, and we did a notice of hearing for today. That was my notice for clarification, because after I looked at your order, it says the stay is lifted and the application for writ for eviction shall be issued in 10 days. I mean,
I don't have any motion for clarification. The only motion I have here is the motion that I just addressed, which is your ex parte motion for a Zoom hearing. There's nothing in the file that represents a motion for clarification. Even if I just consider the fact that you filed this, it makes it clear to me. You said in your motion, you said on or about January 3rd, 2024, this honorable court scheduled an in-person termination of tenancy hearing for January 31st, 2024. So you indicate in your own motion that you understood what today's date was for. And then you proceeded to request to have this hearing by Zoom because you were in Florida. So I believe you knew what today's date was for. I see what your concern is as it relates to any misunderstanding in the court's proposed order that was submitted by counsel. It says something about the stay is lifted and an application in writ of eviction shall issue. That's an error. The court will have that addressed. The portions that the court granted was lifting the stay, and the court also granted the escrow order for $1,000, I think, from $1,000 to $1,600 per month is what the court granted. And that's been taken care, that's been being escrowed.
Some of it has been escrowed, Your Honor, not the full amount.
Okay.
Well,
and so your client is in the back raising his hand, and we can't do anything because you're not here to talk to him.
well, Judge, I can, if you want me to repeat what I said, I will, but I can only go by the information I have. And I do not understand why you do not have the motion for clarification. We filed it at the same time we filed the motion for Zoom.
May I, Your Honor?
Yes.
Mr. Fair is requesting, hoping, looking for an order he can appeal. And he thought he had one, and the order didn't show up timely. So let's give him the order he wants to appeal. Granted Hamilton Road possession and the escrow funds, and he has 10 days from today's date to appeal.
Okay, well, first I'm going to address the order that was signed on 19th. I'm going to edit it myself with my purple pen here because that should not have been on there. And then I'll date that for today that I have edited that portion of the order. As it relates to possession for judgment, today was the date and time that was set for a hearing on termination of tenancy. This matter was scheduled for an in-person proceeding, and we are ready to proceed. I don't believe you have any proofs that you intend to submit to the court, Mr. Fair. Is that correct?
Well, what we would submit to the court, and the court should have it in their record, is our defense to the allegations of the plaintiff, which is the lawsuit that was filed in circuit court and is currently in the appeal to the Michigan Court of Appeals. And that is the issue of quiet title and who actually owns the property.
Okay, who's the parties named in that lawsuit?
The parties named in that lawsuit are, if I could just, I'm pulling this up, Judge, as we speak. The parties in that lawsuit are Innovative Properties 1997 LLC, Matthew J. Brown II, Betty Miller, and the estate of Claude L. Miller.
What's your name?
Daryl Davis.
Okay, this person, the only person you have here is not even named.
This is.
No, he's a tenant who is currently living at the property that's owned by Betty Davis, who is, I understand, too sick to come up to the court. And she's also
someone just walked into the courtroom late in the middle of the proceeding. They said they're Matthew Brown.
Yeah.
The second.
Yeah, and he's a plaintiff in the lawsuit,
Okay.
Circuit Court, and
Got
also Court of Appeals.
Okay. Do you live at the address of? Is it 2518? Is that the address, Pattingale?
Yes.
2518
Sir, do you live, Mr. Brown, do you live at the address of 2518 Pattingale? You do not? Say it so I can hear you.
No, I do not.
Okay. We're here for termination of tenancy. I don't deal with quiet title issues. The only person that you have here, the actual tenant, is not even the person who's a part of this other action. I don't have anything where you got from the court, or the circuit court, or the Court of Appeals staying any other proceedings pending their ruling on any matters that are remotely connected to this. I deal strictly with termination of tenancy. As it relates to that, tenancy will be granted in favor of the plaintiff because of your lack of production of any reasonable evidence to support why you should hold over the tenancy, or your clients should hold over the tenancy. So I will grant eviction in favor of the plaintiff.
Writ date, Your Honor.
What's the word date? Today's the 31st, the 12th, but we have to go ahead and give them a couple extra days because they got to file that through OnBase and they'll kick it out. You can put it on for the 12th if you can get that filed through OnBase today. The issue is if it doesn't go through OnBase in enough time, I have to go and manually change the date. So as of today, the date is the 12th.
In addition, we'd like the escrow funds released to Hamilton Road.
Your Honor, I would like to address that.
You can address that.
Well, Your Honor, we are currently where I thought we were on December the 19th. And again, the court's ruling is fine, obviously, by me. Only thing we ask is two things. Number one is that we get a copy of that order because my clients do intend to appeal to the circuit court. And the only thing I can say to this judge is that this order was entered in December the 19th, and assuming that that was a termination of tenancy, we had until the 29th to appeal. That order was not even mailed to us until January the 3rd. And if you had my motion for clarification, you'd see a copy of it. And I believe Brother Counsel has a copy of it. So it wasn't even mailed out to me until after the 10 days. So only thing, and Judge, if you get a chance to read that motion, my office called the circuit court. We looked at the register of action. We religiously did everything we could to get a copy of that order within the 10-day period. But it wasn't even mailed to after the 10 days. So if the court's going to enter an order, I would ask that it be emailed to me, faxed to me, so we can get a copy of it within the 10 days, so that we can appeal.
The order's going to be filed electronic. We have an electronic filing system.
Oh, absolutely, Judge.
For civil matters.
Absolutely. So then we'll get it within 10 days. So that's number one. Number two, if a possession order is entered, the tenant has a right to appeal and for escrow order to be entered. And so council is not entitled to the escrow. That is something that would happen after the appellate process occurs. My clients.
That's if he appeals, is what you're saying, but he has not appealed yet.
Yeah, but Judge, I've already been retained to appeal. They are going to appeal. Just like
I recognize you've been retained to appeal, but being retained to appeal is not the same as being appealed. It has to, appeal must be filed before you can assert that right. It can't be an intent to appeal.
Well, yeah, and you're absolutely right, Judge. But the fact that they appealed to the Michigan Court of Appeals, that's a good indication that they are going to appeal. And as soon as I get that order, Judge, I will file the appeal.
And that's marvelous. And I don't know how, good luck to them sorting all that out. That's not for me to sort out. But the tenant, and this is a termination of tenancy matter, is not a party in the other matters.
Yeah, and I get that. But the point being is that we intend to appeal the termination to the circuit court within the 10 days. Okay, well, you can appeal the termination if you want, that's fine. But what I'm saying is that this tenant is not a party in any other matter. Technically, if you ask me, I think it's even a conflict for you to try to represent the owners and the tenant. I think that's somewhat of a conflict, but that's for them to decide if they want to waive that conflict. And apparently they have. But again, the only person I have here is one person that says they live in the property, another person who doesn't live in the property, doesn't have any name, a stake in the possession or the tenancy issue. That Mr. Brown, I'm assuming, is a party to the title action, the quiet title action that's before another court. I don't deal with that here. And that's fine, Your Honor. Okay, so once we get the signed order on base, then and you should, I'm assuming, have a electronic MyFile account, correct? Yes, I do. Okay. So and I see here where our last order was mailed to you on the 3rd, and that's probably because that's when I signed it, or around the time that I signed it. It wasn't signed just because we had the date of the hearing that day. And again, with the new filing system being the way it is, things have been much delayed during the holidays. Our civil department's even closed 2 hours a day trying to catch up. That none of those things should prevent you from being able to file whatever appeals you feel that you want to file. We'll make sure that order is filed by the plaintiff, and the court will review it and sign it.
Your Honor, I'd like this order to.
No, Judge, I haven't finished. I haven't finished. There's just one other thing that I am a little concerned about, is that you don't have a copy of our motion for clarification, because we filed that through the system also. So I'm not sure what we have to do on our side to make sure you get copies of the pleadings that we filed. And there appears in my file, there is a motion in there. It's not in my physical copy or file that I have here. The only thing that was on my desk physical when I got here was the motion to address your Zoom hearing. And that's the only matter that they set for a hearing today. They didn't set the other matter for a hearing. Outside of that, it's really a moot issue, because the court just already addressed the issue, which was when Mr. Turnwell filed his proposed order, which is the order for a motion for reconsideration, which was filed under the 7-day rule, and you had an opportunity to review and object. There obviously was an error there. The court has addressed that error. You could have and should have caught that error under the 7-day rule, but for whatever reason, that didn't happen. And then also, based on your motion, you knew that today's date was set for a termination of tenancy hearing. So I don't believe that you believe that there was a ruling on that if we had a hearing. It's unreasonable for me to think that you think that we've addressed that if you're asking to have the termination of tenancy hearing via Zoom. No, Judge. Judge, I just, I think part of the problem is that you have not read my motion for clarification. And what concerns me is I'm filing motions and they're not getting to you, Judge, the most important person. I've heard your rendition of the facts, but I think if you had a chance to read my motion for clarification, you would view this, what I'm saying, a little differently than the way you're viewing it now. And the only thing I'm saying, Judge, is I'm filing motions, they're not getting before you, and then you're having a half look of the position that we're taking. But having said that, the only reason I brought this up is because when I'm filing motions, they're not, for some reason, getting to the court. That motion for the Zoom was also filed.
How many motions have you filed that's not gotten to the court?
Oh, okay. With regards to the motion for reconsideration, that didn't get before the court.
Your motion for reconsideration did get to the court. It's in the file.
The response at the last hearing, you said you didn't have it.
No, we got a motion for reconsideration. I don't know about another response that you filed, but that wasn't filed electronically.
No, that response, the response we had for their motion for reconsideration, when we were at the hearing on the 19th, you said you didn't have it. And we filed it. I mean, I spend time working on these briefs and then and I file them and then you don't know about it.
I don't know. Maybe the mail goes longer from Florida. I don't know. I don't know why it didn't. That
Your Honor,
wasn't here.
it didn't make it to your court file because he never set a hearing date for the motion for reconsideration. No, I mean, for the motion for clarification. There's no hearing date on it.
I just told you that it's not set for a hearing before me.
And the other problem was when he filed his responses to my motion for reconsideration, the court rule doesn't allow a response to the motion for reconsideration. And also it was improperly filed and the court clerk system rejected it.
Well, that's not exactly what happened, Judge. And so we don't keep going back and forth.
I don't want to go back. That's the last thing I want to do on this case any further. I have spent all the time on this case I ever would like to spend on an eviction case. This matter has been pending before me, and I've been looking at this file since June, before you were in Florida. And so now here we are in 2024. I've made my ruling. You now have the order that you need, or you'll get the order that you need so that you can process whatever appeals you want to do for your client as it relates to termination of tenancy. Any other matters for today?
The order should, I'd like the order to reflect that Hamilton Road receives the escrow funds. And if they truly do appeal it, simply address a new escrow order at that time.
Yeah, the escrow funds will be released to Hamilton Road unless there is a appeal filed. That's
right, exactly. Right, exactly.
Okay, thank you.
No problem.
That's what the law says.
Any additional matters for the record?
I have none, Your Honor.
I am preparing an order and I will hand it to you, Your Honor.
Actually, we need your order filed electronically.
Okay, thank you, Your Honor.
Thank you. You're all set for today.
Well, if you send me the order, I'll sign off on it.
I prefer that.
Yeah. So Turnbull, why don't you send it to me and I'll sign off on it, and so there won't be any issues before the judge.
No, we've been down this road. Where are you? What is your address?
You're welcome to come down.
What city are you in now?
Can you email it to me?
My email is the same.
I see dpfair@dpfairlaw.com.
Right, and I get correspondence from courts all over, Judge. And I get correspondence from lawyers all over. They send it to my email.
Sounds good. Yeah, I agree that you can get it by email.
Right. Okay.
That.
Your Honor, my boss, my secretary says he won't sign it today, so therefore we can't enter it today.
What do you mean?
Why wouldn't he sign it today? Well, Mr. Fair, if you receive it today, will you sign it today?
Absolutely, Judge.
Wonderful.
Okay, thank you, Your Honor.
All right, you're all set. They'll send it to you via email.
All right, thanks, Judge.
You're welcome.
This matter is closed. I can leave.
It's closed.
Okay, thanks.
Thank you. Good afternoon. Do we have any tenants here?
Two tenants are out in the hall. Yeah, the default. So,
On which one?
the
leaks?
Grove. Leak,
They didn't appear.
they're not here.
Let's see here. Okay, on the record, in the matter of the Grove versus Kia leak, file number is 23-02921. Council, can I have your appearance?
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, the Grove.
Okay, today was the date and time that was set for a hearing for non-payment of rent, but only as to Lakia Leak. My understanding is that London Link is an 8-year-old. I dismissed her.
That's correct.
Okay, okay, as to Lakia Leak, a default will enter.
Your Honor, I have a default judgment prepared if I may approach.
Yes, thank you.
And I'd also add, Your Honor, I think the default supported by the testimony previously taken by the courtroom. We did start a trial.
Okay, very good. I can see that here, and I will sign and date that for today. What date is the 12th of February? Any additional matters for the record?
Nothing on this matter, Your Honor. Thank you.
Okay, on the record, in the matter of Aspar LLC versus Richard and Beverly Williams, file number is 23-02920 LT.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Aspar LLC.
And what's your name, ma'am?
Beverly G. Williams.
Very good. And your name, sir?
Richard Norman Williams.
Okay, today was the date and the time that was set for a hearing for non-payment of rent. Did the parties meet today?
We met at length, Your Honor.
Okay, did you come to any resolution?
We have been unable to do so.
Okay, so this is for non-payment of rent, and I'm assuming that there's been no resolution because you believe there's a lawful reason whereby you could withhold your rent?
Yes, ma'am.
Okay, and you have evidence or proofs to support that?
Yes, ma'am.
Okay. Have a seat.
Oh,
What is it that you're pulling out of your pocket? We don't insert discs in court stuff. We don't know what's on that disc. You can corrupt the whole court system
no, it's
with the
photos-
virus.
It's photos of water and then.
I believe that, but we are not allowed to insert external hard drives from people in our computers.
Okay, well, my son has sent it to your secretary or your assistant. And to Andy Nash.
Addie
Judge-
Nash,
Yes, Judge Simmons Courtroom at Lansing, Michigan.gov. She sent some photos to you.
is it in there? What's his name? What's your name?
Well, my son sent it to Richard Moore. Because he has his phone, his smartphone, and I don't. And so he sent it, and then this is the other part, he
What
said
was
just
the
in
email?
case.
What day did he send the email?
I think it was yesterday, man.
From Richard Moore?
Yes,
Do you know what his email address is?
no, I don't.
Can he repeat the email? I think
Pardon?
he said it wrong. What's the email that you said?
That the judge gave me,
That it was sent to?
yes,
Did you send it to Judge Simmons Courtroom at lansingmi.gov?
that's what he said. He said he sent it there, yes, ma'am.
No, we don't have
And then it has an email, Alua, at lss.com. That's the email that she sent me.
That who sent you?
Alicia Hall.
Who's Alicia Hall?
She's the one of the attorneys downtown somewhere where they said that they didn't have anyone for us today. But if we sent them some photos on the hard drive and some information that you would be able to get them. So she sent me the information and I sent it to my son and he sent it here.
We don't have anything. Are you able to go in the hallway and call your son?
Yes, ma'am.
Because we don't have it. He might need to resend it, make sure he has the right email.
Yes, ma'am.
And just for the record, I've received none of this.
Okay. I'm not surprised we didn't receive it either.
If I put it on speaker, ma'am, would that be okay? Because I can't remember what he said.
Can you go in the hallway and find out what's going on?
She said he was hungry. We give him a radio.
It should be Judge Simmons Courtroom at Lansing MI.gov.
You on a road driving as he's doing it. It's illegal for this.
Okay, so the proposed documents that you have are documents that are supposed to show what?
Show the damages of the home to where the water, the rain and the mold in the basement.
Okay,
I didn't
okay. Do you also know that you need to provide a copy of that to the plaintiff's counsel?
No, I didn't know that.
Okay, I'm gonna require that you get his email, make sure he gets a copy, make sure your son provides us the documents to the appropriate email. I'm gonna give you a new court date,
February 28th at 2.
February 28th at 2. Yeah,
Your Honor,
yes.
we're now at a balance of $9,400. I'd like to request an escrow. The case is going to adjourn another.
The case is going to adjourn another month. You can file an escrow order, I'll sign it. Escrow meaning you're gonna have to put your rent up in an escrow at the court. You understand that?
Yeah.
Okay, and so they're gonna get an order to the court so that we can order that. You have to put your a 1 month's rent in escrow here at the court, no later. Your rent is due the first of the month. Is that correct? On the 3rd? Okay, you need to make sure your escrow your rent no later than the 9th of February.
Yeah, Your Honor, it's due on the 1st of the month. I think they're talking about a grace period. The lease says the 1st.
Okay, still gonna be the
We
9th.
haven't done anything to deserve that.
To deserve an escrow?
Yes.
Well, escrow is just that the court is allowed to order escrow, meaning you show good faith, because you don't get to live for free. And if what you're saying is that the conditions of the property is so deplorable that you should be able to withhold your rent, then in good faith, you put your money up, the rent money up at the court. And the court will make a determination as to whether or not you can withhold that rent once you provide those proofs at our hearing.
Okay.
If we find that you're right, that the conditions were that deplorable and you were effectively, evicted based on the conditions, then we give you the money back. If we find out actually the conditions were not that deplorable, then we give them all, or maybe we may give a portion back to them because we think that, there was some issues there.
So I give him a copy. Now, how do I do that?
Well, your son seems like he's emailing it. You get his email account so that he can email it to you as well. I mean, you email it to him as well. He has to be able to review these photos and review them with his client, and they may dispute them. They may look at it and say, you know what, you're right, let's come to a resolution. Who knows? But they need to be able to know what you're claiming before they come in here to court today, to argue, okay? So you got his email there. You want to get on the phone with your son when he's not driving. Make sure that he sends the evidence that you want to submit to Mr. Whitty this week. And then you also want to make sure that that evidence is provided to the correct email for the court, which is the Judge Simmons courtroom at lansingmi.gov.
This week
Okay.
today is, you get this in by.
You need to get him that evidence as soon as possible.
Okay, I could.
But then you said we have to,
Escrow?
yeah.
The escrow, you need to take care of that. I'm gonna give you to the 9th to escrow your rent at the
That's
court.
what I was thinking.
Yep. Okay,
Can I get the email address for you so that we can send you?
Yeah, because I'm trying to get out of there, man. I'm being honest with you.
he wants your email address.
Oh, Richard. NW 258.
Sounds good. Other than that, we'll get you your notice to appear and you're all set for today.
Thank you.
Thank you.
Oh, this is the information for the escrow.
No, this is your notice to appear. Mr. Woody's gonna file an escrow order. I have to sign it. And then you have until the 9th to escrow at the court. You'll go to the 5th floor, which is the clerk's office on the 5th floor.
So we can take that paper with us, or it's gonna be mailed?
Paper.
I'm not gonna remember.
You'll get it mailed to you.
Thank you.
You're welcome.
Appreciate your time today.
Thank you.
Thank you.
Let's go, buddy. Ready back.
Well, that grandma, yeah,